Joining us now in the studio, attorney with Balch Bingham, my longtime friend and counsel, Pepper Crutcher. Morning, Pepper. Thanks for coming in.
Good morning. Happy to be here.
Well, I suggested to Alex we get you on the show. We thought it was rather timely given all this buzz about these companies. We just talked about, as you heard, Disney and Walmart mandating vaccinations. And then there's, of course, the various COVID protocols that are instituted by private sector companies. And there's always this question about how far can they go? What is legal with respect to that? What rights and authority do employers have relative to employment conditions for employees? And I don't know if I'm explaining that in proper legal context, but you know what I'm talking about.
Yeah, yes, I do. These are questions we're getting multiple times a day.
I'm sure.
And before I start answering anything, let me say some of your listeners know me because of my association with clients, like I'm general counsel of the Manufacturers Association.
Yep.
Some of your listeners know me as a Federal Society underboss. I founded the Federal Society in Mississippi.
Yep.
I'm not speaking for any client or any person within them. So I'm just these are Pepper Crutcher's opinions and maybe even rants.
Okay.
The concern I've had about mandating an emergency use authorized vaccine is that there might be conflict with the emergency use authorization statute, which says every subject of the vaccine must be allowed a free choice to take it or not. And that could have adverse consequences under state law, for example, for whether or not workers' compensation is your exclusive remedy for an injury. The Department of Justice last week came out with advice saying the emergency use authorization statute does not have any adverse consequences for employers that mandate a vaccine under federal law. They didn't answer the state law question of it. But I think that's about to be a moot question because I think you're about to see, my guess is Halloween, you're going to see final authorizations of at least 3 vaccines, and that issue will go away. And then you have left the issues about can you mandate a vaccine absolute? You cannot mandate it absolutely. EEOC says you have to allow for religious accommodation. You have to allow for disability accommodation. There are some people for whom these vaccines are contraindicated because of existing disabilities.
Yeah.
And you have to be willing to accommodate those people, and you have to say so in advance. You can't just flat mandate it for everybody.
Okay. All right. So with respect to Disney, I'm going to ask you this question because I think it's labor-related. So they're saying that this mandate that employees be vaccinated only applies to, I think, hourly non-union employees. Does that sound right?
I don't know. You're ahead of me on that.
Excuse me, salaried non-union hourly workers.
Well, I can tell you why they might make that distinction, although I'm not familiar with the story you're looking at.
Okay.
An employer that has union-represented employees has a duty to bargain about wages, hours, and working conditions before changing wages, hours, and working conditions, and unions across the country are taking the position that COVID rules are working conditions, and you can't change them or make up new ones unless you bargain with us in advance. And so there may be bargaining going on behind the scenes, and that may be why they have separated those people out.
Yeah. It does appear, however, that all newly hired employees, regardless of status with respect to union. I suspect that's part of their union agreement, that it may be some different application of standards to existing employees versus new.
I don't know, but I do know that is a fairly common way to resolve disputes with a union. I have negotiated such deals where we say, okay, the people who are current employees, doesn't apply to them, but everybody new, we got this new rule in effect.
Yeah, and obviously I don't know how many Disney's employees are union. I don't know that matters, but especially being in a fair number of them being in Florida, which I assume is a right-to-work state.
Yes.
Yeah. So you would think that then a smaller number of their workforce is unionized. But so this is a complicated matter. Well, so you practice in Mississippi primarily.
Yes.
Where else are you licensed, by the way? It's not a funny question.
Okay. Alabama, Arkansas, Louisiana, Mississippi, Texas, and pending in Tennessee.
Okay. So a big swath of the southern United States.
Like the song says, I get around.
I like it. Okay, so what do you expect in Mississippi? Are you familiar with any mandates that have been instituted by Mississippi-based companies? Do you have any clients? You don't have to obviously share names.
I can't.
Yeah, I know you can't.
Here, I can tell you where I think we're headed.
Okay.
unless we're looking at a peak that's about to drop off and the issue goes away, which I don't think that's happening anytime soon.
Yeah.
What I think you will see is people saying, all right, you've got to mask up. And if you want to avoid the mask mandate at work, you've got to show us your vaccination record.
Okay.
Or you're being masked and you're being tested periodically if you are not willing to be vaccinated. That's where I think we're headed for a lot of employers. And
that would stand the test of a legal protest, I guess?
There is nothing on earth you can't sue over.
Of course not. You and I have had that discussion before.
Employers don't look for something they can't be sued for. They look for what's the most defensible position.
Yeah,
and that's probably where a lot of employers are headed right now.
Well, you're right. A few bucks and a filing fee gets you a lawsuit, right? I mean, it seems like that's about all it takes. It's too easy, it seems like.
My favorite, actually, I wrote a very long article many years ago about employee attorneys who got sanctioned for their lawsuits, and one of them sued Kentucky Fried Chicken for a civil rights violation and claimed that the use of Kentucky was state action.
Oh my gosh!
You can literally sue for anything.
And we jam the courts up with all sorts of frivolous nonsense like that too.
Have you seen Elon Musk's recent pronouncement? I really admire this guy for a lot of reasons. I drive a Tesla. Full disclosure.
Yeah.
His recent announcement was, we're not going to contest fair claims. If we owe it, we owe it. We're also not going to give in to unfair claims that we don't owe.
Okay.
If every civil defendant in America would take that position and stick to it, our legal system would change in a matter of weeks.
I believe that. Do you?
Yes. I do.
I mean, and you and I have had to deal with matters like that where we've had to make those decisions. Do you invest in this? Because it's an investment. Is it worth investing in and falling on the sword, or just fall on the sword and just hit the hip? So, and it's a dicey decision that we in the C-suite have to make. Fortunately, knock on wood here, I was fairly fortunate in that really didn't have a lot of challenging lawsuits thrown at me. One competitor, one customer, and one employee. 3 in my 33-year career. We were fortunate, I feel like, with that. Almost anybody out there operating a business, they're familiar with some party suing them, be it for some sort of valid action where they were wrong, the defendant was wrong or not. That seems to be irrelevant. Sometimes it's just a shakedown.
I have friends who are trial lawyers, and I don't want to accuse them of being engaged in shakedowns. On the other hand, it is true that lots of employers literally can't afford to defend a case in which they have no liability. Right.
But the thing that's frustrating to me, and you and I have had this discussion before as a business owner, is that so often the facts don't matter, that it really doesn't. And even when you advance all the way to a court setting and you've got a jury, the jury, to them often, honestly, the facts don't matter. And it's just, well, let's see, it looks like you got more money than them. You just give them some. That's kind of what the default decision is.
I know that's the public impression. I'm not sure it's accurate.
Okay.
But I try more arbitrations than anything else.
Okay.
And I can tell you that in my experience, an arbitrator is very often a jury of 1. I'll take a jury of 6 or 8 or 12 anytime.
Okay. Yeah, I hear you on that. It ain't fun no matter what, I should just say, and you want to try to avoid it. And then, of course, if there's insurance at play, you got to deal with the insurance aspect of it as well. Often they make the call.
Yes. And that's probably the last thing I should say on that subject. Off air, I'll tell you more.
Okay. Well, I mean, I'm speaking from personal experience, honestly, so I'm happy to share that. All right, so we got a break right here. You can stay, huh?
Yeah, sure.
All right, when we come back, I want to talk about this article you wrote with respect to OSHA and how that figures into COVID protocols and what employers need to be concerned about and kind of how far they can sort of stretch that rope. We'll see. Pepper Crutcher from Balch Bingham, attorney there, specializes in labor law. We'll be right back. We got Pepper Crutcher. He's an attorney with Balch Bingham. We're just talking about these various employer mandates with respect to masks and other COVID protocols and vaccinations. Pepper is a long-time practicing attorney. Do you call it employment law or labor law, Pepper?
Both. We say labor and employment law.
Okay. All right. So, and full disclosure, Pepper has acted in that capacity for my company. We were thinking about it. I think it's 1987, 1988. You like to refer it to when you were a baby lawyer.
Yes.
You're still a baby lawyer.
Thank you.
It was, I think I got introduced to you by Delbert Hoseman.
Yeah.
You guys were at the same firm
Yes.
at the time,
Yes.
and Delbert was doing my general corporate work. And so Pepper has guided me through many challenging situations, and I appreciate that, Pepper. But I trust him a whole lot, and you need someone you trust when you're dealing with those kinds of matters for sure. And you got to realize your limitations, and so that's an area in which I'm limited, and that's what makes the world go round.
Man's got to know his limitations.
You've got that right. What I've noticed is, and I'm not trying to pat myself on the back here, smart people tend to know their limitations better than people not so smart. You ever thought about that before?
That's true. It's also true that smart people doing dumb things is why I stay in business.
Okay, good enough, fair enough. Are you insinuating I did dumb things?
No. You were a terrible client.
Terrible client. Well, okay, that's one way to look at it. All right, so a couple of people are also texting in about Home Depot. Yes, I did catch an interview with Ken Langone, one of the co-founders of Home Depot. He is an incredible conservative voice for the private sector. Did see an interview with him and Maria Bartiromo last week. He did also indicate they intend to institute mandatory vaccines coming up, I think, once the vaccines obtain full FDA approval. But just a few hours ago, it appears they've reinstituted mask mandates for employees and I think for customers. So this is no surprise, honestly. So let's talk about your sort of tying that in to OSHA. I never really thought about how OSHA may play into this, but Occupational Safe, what does it stand for?
Occupational Safety and Health Administration.
Okay,
And it's
there you
created
go.
by the Occupational Safety and Health Act back in the 1970s.
Okay.
And they have for a long time proposed and imposed medical removal rules, for
Okay.
example, under their lead standard that's decades old.
Yeah.
What's new here, and the reason I wrote the article that'll be published on the Federal Society website shortly, is that Congress had, in effect, a medical removal standard in the Paid Sick Leave Act that they allowed to expire at the end of 2020.
Okay.
And OSHA, without any new congressional authority, has now come back and reimposed the equivalent of paid sick leave on healthcare employers who are not exempt. And there are 6 different ways you can make yourself exempt.
Okay.
Imposed that requirement on employers, and they have created a new condition in which an employee can demand paid leave that can't be verified by the employer. And that is, have you lost a sense of smell or taste not otherwise explained? There's no test for that that the employee tells you they have or tells you they haven't. Every employer I know of is struggling to get applicant flow and hurting for labor. And the last thing we should want in a pandemic is for healthcare employers not to have the labor they need. Congress recognized that in the Paid Sick Leave Act, and they allowed healthcare employers to exclude their employees from the paid leave. OSHA hasn't done that. In fact, OSHA has targeted healthcare employers for this new paid leave requirement and has created a condition of paid leave that employers can't even verify.
Yeah.
I think that could become problematic. We're facing a bad employment shortage in healthcare right now.
Yeah, it's across the spectrum of industries, of course. But so there's a question on the C Spire text line here. This is Karen and Ripley, and she wants to know if an employee could request that their employer pay for an antibody test. I don't know if she means that in lieu of a vaccination, for example. Look, I have herd immunity. I don't need the vaccination. If that's perhaps where she's going with that, but I'm sure you can request it. The question is, does the employer, are they compelled to pay for it legally?
Unless they've negotiated an agreement, for example, with the union that requires that, very probably not. The one exception I can think of is if you're engaged in some sort of disability accommodation discussion, and that became relevant, and if the employer wanted to make a decision on that basis, then it would have a duty to pay for the test.
I got you. Yeah, that makes total sense. But so what about in the public sector? What sort of authority would a public sector agency, let's say a school district, could they require, for example, that all of their teacher staff, all their workers be vaccinated? Is there sort of a different standard applied to public sector versus the private sector from an employee-employer relationship perspective?
The big difference is that public sector employees have constitutional rights because government is their employer that are not enjoyed by private sector employees. Before I say anything else, I need to let you know that I have studiously avoided, to the extent possible, being a public sector employment lawyer because of my experience as a baby lawyer in Louisiana representing the reformers who got elected to kick out Leander Perez and Plaquemines Parish. I swore off representation of public employers.
Oh, well.
I hope none of them are listening.
We got you.
But yes, in most respects, the rules are going to be the same for public and private employers.
Wow. Okay. So, little different standard, a little bit different application of the standard.
Yes, there's a whole lot more law on public employment in states like Mississippi than there is on private employment.
Yeah. So this is from Mike in Richton. He says, I know of one company in Alabama with less than 25 employees and required them to take the shot, but sign a letter to hold employer harmless before the shot, sort of a waiver, I guess. Will that stand up in court?
It's a general rule that an employer can't require an employee to waive liability for the employer's negligence in advance. If that could be done, you would have no employee ever entitled to get a workers' compensation remedy, for example.
Okay. So
it may have legal relevance otherwise. For example, if you needed to prove that the employee was aware of the risk, then having the signature on the document that informed them of the risk could be legally relevant.
Yeah. All right, so I guess I'll just state what you lawyer guys have always told me through my career is, you know, if you're negligent, that's one thing. But if you're grossly negligent, they always use grossly as kind of the adjective to precede the word negligent as a distinction. And in operating a data center, you know, I guess an example that one of my lawyers that helped us with the contracts in that regard said, is as an example, if you just sort of overlooked some technical procedure and that caused some problem, some, say, monetary loss for your customer, you got some liability. But it's not the same as if one of your employees came in one day and took a gun or a knife to servers and started chopping them up. That's grossly negligent. You got no leg to stand on. That's kind of the way it was explained to me.
If you're an employer resisting a claim of liability, the last thing you want to be true is that you're aware of a risk and you made a conscious decision without balancing any interest to ignore it.
Okay. Yeah. I got you. All right. So then here's another question that comes up. What about the right of an employer to ask vaccination status of an employee? A lot of folks think, well, that violates HIPAA, and therefore they can't do that. I have a view on this and have expressed it on the air. Please proceed.
Among my nerdy lawyer buddies, HIPAA is a running joke. The scope of things that people think are covered by HIPAA has gotten literally to the comic level. No, that is not a HIPAA violation.
Okay.
Very few things are actually HIPAA violations. We won't go into that. But where I think this is going is employers are going to say, hey, there's going to be weekly testing or maybe monthly testing, and there's going to be full masking. And if you want to be out of that regime, fine, just show us your vaccination proof.
Yeah. So, but then the employer has a duty, right, to protect the confidentiality of such information. Is that? I think that actually is covered by HIPAA. Is that?
Actually, no, but it is covered by the Americans with Disability Act.
Okay.
To the extent the employee has a medical file, that medical file must be separate from personal information and must be confidential.
Okay. So it's not really a HIPAA standard. It's just it existed before HIPAA, sounds like.
Very few things are HIPAA problems, actually.
In the IT world, it's the HITECH Act that sort of codified it from a digital context. It probably has more teeth in it than base HIPAA does.
There's privacy and there's security and there are different things, and they're very detailed, and there are big gaps. But where they apply, they have teeth.
I got you. Pepper, thanks for coming on, man. We'll do it again. Appreciate it.
Thank you.
Pepper Crutcher, labor and employment attorney with Balch and Bingham. We appreciate him coming on. We'll be right back with more talk here on the JT Show. Stay with us.